glad to be looking at some of these land use issues. As I explained, I did focus on solar and wind a long time ago and have been following it from time to time. Okay, so basically I'm going to go very quickly over some of the permitting and environmental and land use issues. And I'm going to do that because California has identified that planning, permitting, and environmental issues are important challenges to meeting its RPS targets. And I'm going to focus on solar and wind since I know something about these two. First, let me just say that the state agrees that a lot of the environmental challenges at the utility scale to renewables, it's to a large extent because they are being sited in desert locations. So we're dealing with locations in the Mojave and Colorado deserts, and in Northern California in the South San Joaquin Valley. And of course, these are projects that are massive, and they're being built on undisturbed or sensitive lands that trigger environmental concerns. And further, most of the projects are being located in land owned by the federal government and managed for multiple uses, recreation, wildlife habitats, livestock, and open space, and so on. And so this is a major reason for some of these concerns. And here, basically, I identify a number of the environmental and cultural issues that you've all heard about, especially if you live in the LA area, because the LA Times has been having a series of articles that detail problems with solar and wind projects. In particular, the conflicts related to sensitive plants and species, and also, more recently, cultural resources. I think just a few days ago, there was an article on the Genesis site, where there was a discovery of Native American ceremonial burial sites and so on. And so all of these are extremely important for these kinds of renewable projects, because when you find out that there is an environmental problem, it means tremendous delays. And of course, delays means money. One of the major problems identified are permitting issues. And in particular, there are two kinds of permitting issues. There are the federal state permitting issues, and then there are the local permitting issues. So first, let's focus on the local permitting issues. Basically, both the federal government and state regulations have pretty much similar protocols, but there are variations. And because they have overlapping licensing authority, it really means that the process is lengthier and that there is uncertainty and delays. For example, there are key permit processes that include separate permits for biological resources under the Endangered Species Act, air quality permits, water quality permits, federal land use entitlements, and so on. And all of that, of course, makes it rather difficult to manage a project in time. And then there are local permitting challenges at the utility scale type of projects. For example, counties typically review and permit utility scale solar PV and wind energy projects, and they require multidisciplinary California Environmental Quality Act analysis and public comments and hearing processes and so on. One of the problems is that local governments typically do not include utility scale renewable facilities in their general plan or zoning ordinances, and developers often have to apply for general plan amendments and rezoning and this, of course, results in delays. And today, because local governments face resource constraints, since many have been downsized and so on, it's more and more difficult to get these changes made in a timely way. And often, planning departments lack the technical expertise to undertake these reviews. But there are some emerging solutions. For example, the state has learned that basically, in order to really avoid some of these problems, you really have to do the planning and analysis at a regional scale that will identify the sensitive species, the water bodies that may be threatened and so on, and also develop conservation plans. And there is one recent example of the Desert Renewable Energy Conservation Plan that is undertaking this kind of approach. So basically, you have to analyze and plan before the developers come knocking at your door. Also, I think very important is to establish explicit compensatory processes for situations where you've got endangered species in federal lands, or when you have other cultural concerns and so on. Because if you establish these processes, it means that once you find them, you can then basically quicken the process to get to a permit. And of course, that public participation and stakeholder processes are really important parts of any kind of renewable development. Agency coordination problems are endemic to almost any kind of major development project, whether for renewable energy or anything else. And so there have been quite a number of efforts to coordinate agencies' responses and so on. But of course, there's a lot more work to be done. And there's some movement on the local plans and zoning issues that have come up. For example, the California County Planning Directors Association is developing a statewide model ordinance for solar electric facilities. Kern County as well serves as a model because it has included renewable energy facilities in their county general plans and also in their county zoning ordinance and so on. I want to just tell you a little bit about some of the permitting challenges for distributed generation. And again, very similar to utility scale, many cities and counties require lengthy general plan amendments and rezones, although rooftop photovoltaic is not a problem because of the Solar Rights Act, California's Solar Rights Act, and I'm going to talk about that in a minute or so. Another problem is that there are varying codes, standards, and fees, and there's tremendous variation across the jurisdictions. Just as an example, in LA County, a range of fees for commercial PV projects of about 131 kilowatt hours in size varied from $0 to $46,000. That was a great variation. And also there's a lot of complaints that the local review fees are based on the cost of the project rather than the review time. It may take 4 or 5 hours to review, and the cost of that is obviously not the same if you price this as a percentage of the cost of the project. And then there are duplicative and uncoordinated permitting processes requiring permits from the fire department, building department, electrical code officials, and so on, local air districts before receiving a zoning clearance. And then there is CEQA and NEPA, so that if there is an environmental impact review that is necessary, it may mean expensive mitigation requirements. But there are emerging solutions here too. And one of these is that first, communities should really identify the best locations for renewable projects and try to avoid those that may create more problems for developers. And then The Department of Energy has the Solar America Cities project that has worked with cities to identify barriers and to develop solutions. San Diego has expedited permitting for solar, for example. And then another example is that DOE last year launched a program with a purse of money attached to it to reduce administrative costs for PV. For example, for localities, if they actually do, after competing, win one of these grants, they can use the money to streamline, to standardize and digitize administrative processes. Okay, so I want to end my presentation by addressing what I think is going to be an emerging urban solar access issue. As I explained, California has a solar access law that pretty much guarantees solar access on rooftops. This is a law that comes to us from 1978, and basically at that time, during the height of some of the energy crisis at that time, it voided covenants that prohibited or restricted solar access solar installations in homeowners associations, because I don't know how much you know about homeowners associations, but they have basically covenants that restrict all kinds of things in terms of materials, of the way you paint your house, and so on. And at that time, there were some associations that basically thought that solar installations were ugly and so on, and they didn't really permit them. And so this Solar Rights Act was really focused on some of these issues. It also allowed solar easements, which are agreements between adjoining property owners, so that the property owner that has installed a solar rooftop panels, basically that they won't be shaded by any kind of changes that the adjoining property owner may entertain. And basically, the law in '78 allowed these easements, but basically you really do have to get agreement, and it has to be on paper and so on. And it also discouraged local governments from restricting solar installations. The law was really geared to foster the installations of solar, to a large extent, water heating systems and so on. But there was another law, and that is the Solar Shade Control Act that was amended in 2007. And this one protected owners of solar collectors from shading of trees. And at first, basically, the shading of trees was really a public nuisance, which meant that in 2004 or 6, in the city of Sunnyvale, a property owner was actually prosecuted by the district attorney because he had a small grove of redwood trees, and they shaded a new solar installation. And so he was convicted, actually, and there was a fine imposed of $1,000 and so on. But that brought about a change in the Solar Shade Control Act. And it went from a public nuisance to a private nuisance, which means that the law still applies, but if someone shades your installation, you have to take it up in court. And really, it has to come out of your pocket and so on, and you don't have the district attorney to work on you and so on. And it's a famous case that brought about changes. But so I want to now talk to you about why this is important. And I think it is important in cities like LA, especially now that we have passed this feed-in tariff, which will mean that there will be a lot more solar installations in residential and commercial, unresidential and commercial properties and so on. And I think that this could bring about, as more and more solar installations happen, it could mean a conflict in certain areas. For example, one of the things that the city of LA is very interested in doing is promoting transit-oriented development. And transit-oriented development basically means that you, in order for it to work, it means that you are going to have to upzone the area, that is, increase the density in the area surrounding the transit station. And typically it means that you are increasing the density from relatively low density to higher density. And the TODs, the transit-oriented areas, basically adjoin residential areas. And it doesn't take much for you to think about a situation where you've got an adjoining property in a low residential area with a solar installation that basically gets shaded by higher density residential, which is also very desirable, right? And if you have had any experience with changes in zoning to promote higher densities, you know that this is something that is fought over by communities, I mean, tooth and nail. And it means that a lot of these projects are delayed for a very long time and so on. And so, and also, when you've got places like downtown Los Angeles, where you've got areas that the city would like to see redeveloped at higher intensity and so on, and where you have a zoning that is flexible, that allows buildings of different height and bulk and so on, it means that if you do install solar on the rooftop, the next developer may shade your property. And so I think we have options. Basically, we can do nothing about this and allow the conflicts to occur and be resolved privately. And I think this is a kind of worst case, because it could mean long litigation in courts. There could be some property owners that may hold development that is desirable from the standpoint of the city's long-term goals, basically hold them for ransom in courts and so on. And also, you have to think about, in a sense, trade-offs. Yes, a solar rooftop installation will reduce carbon emissions by a certain amount, but a transit-oriented zone, for example, or downtown redevelopment may contribute more to carbon emissions reductions than a small-scale solar project. And so to me, to avoid these potential conflicts that I think will occur in LA, cities can actually do a number of things. They can specify, for example, solar access areas with different, perhaps, types of protection for areas depending on the zoning of an area. The city of Boulder, for example, provides very strong protections for low-density residential areas, but provides pretty much no protection for mixed use and commercial zones unless you get a solar access permit. And you know, there's a process for that and so on. Also, I think that cities like LA, can develop guidelines for addressing solar access impairment by adjacent development. And I think here again, cities can actually be very explicit about the potential compensation that a solar installation can obtain if a new development will shade their property, because we now know pretty much the value of the solar installation based on costs and returns of the installation over time and so on. And this could prevent some of the problems that I identified. So in conclusion, there are a number of ways that environmental or cultural land use conflicts can be reduced through prior evaluation and suitability analysis of sites for renewable energy development and through conservation plans as well. Permitting, obviously, we always need better coordination. And in particular, we need local plans and zoning permitting that are incorporated into the existing plans to facilitate renewable projects. And when we're dealing with urban solar installations, I think to avoid conflicts, cities may need to address solar access more specifically than the state solar access laws actually do today. Thank you very much. And now maybe we can